Welcome to Garden Views, interesting conversations with interesting people who have done and or are doing interesting things. So sit back and enjoy. Welcome everybody into Garden Views. We are continuing our exploration into space, the final frontier, and to the laws of man and space, and trying to extrapolate same or learn what exists and what might be. So about 2 or 3 episodes ago, I had Jeremy Conrad on, who is a journalist for the DC Bar Journal, and he interviewed a couple of law professors. So you should definitely check out that episode. In fact, you should probably check out every episode, period, but especially from Holly DeRemus, The Law of the Sea, to all of the others, which seem to be transportation and space-based, because they're all tied in together. So Jeremy interviewed 2 law professors in his article, or at least quoted 2, and I reached out to both of them. And one of them is with us today. The other one hopefully we'll have in a few months. But it's Professor David A. Koplow. He's from Georgetown University Law Center. So thank you very much, Professor Koplow, for joining us.
Well, it's a great pleasure to be with you. Thank you for inviting me.
Great. I pronounced your name right?
That's it.
All right. Good for me. All right. So I got the first thing right. So obviously, Jeremy spoke to you, and he was a great guest, and I'm really happy to have you on the show. And I was so happy to learn, not just from Jeremy and from yourself, but also I recently spoke to Matt Williams, who's also a journalist and an author who's works with Fraser Cain and the Astronomy Cast and some of those folks, knows Avi Loeb. And he's indicated that there's organizations sort of working on the same project that I am. Just thank goodness some lawyer doing a podcast in his off time isn't the only person thinking about this. But tell the folks a little bit about yourself, your background. We do have an international audience, so you can tell them a little bit about Georgetown if you like, and your studies and with particularity this topic.
Sure. So I am a professor at the Georgetown Law School in Washington, D.C., and my specialties there are international law and national security law, and space is a part of all of that. Georgetown, depending on how you count, might be the biggest law school in the country and one of the biggest law schools in the world. And because of the size, we're able to offer a huge curriculum in international areas, and including space. And so we've got faculty and students who are interested in the legal dimensions of all of this activity.
What a time to be alive. If I was a student, I would definitely enroll in that. Whether you take the cynical approach or the most optimistic approach, this is an emerging area. There's not a lot of times in your life when you get to be on practically the bottom level of something. So here you are, folks. It's like, the Phoenicians have first learned to set sail or whatever, and you could be their legal counsel. So this is second generation, but you're almost there. And listen, there's only one person at the top of the pyramid, but the people at the next level are usually pretty happy as well. Anyway, so that is terrific. Georgetown is a very prestigious law school in Washington, D.C. Everyone's heard of Georgetown from TV and movies, even if you're in my straw man country of Jeffzikistan, which, by the way, if I don't want to say the wrong thing or be impolitic or throw another country under the bus, I use Jeffzikistan as my straw man, so feel free to do the same. And just so that you know, Jeffzikistan is a noble country, but like Panama, it accepts flagging and gives lots of liability protection in exchange for money for the exact purposes. And so that's as the premier and the viceroy of Jeffzikistan, that would be me, because I have questions about the space liability of debris. And I wasn't clear that Matt or Jeremy were 100% on it. I think they were, but I'm still not. So let's assume I'm the slow one. But if the United States of America decides to launch a mission from Jeffzikistan, and at the same time, at the other side of Jeffzikistan Lake, SpaceX also decides to launch a rocket on the sovereign territory of Jeffzikistan, and something goes wrong and it blows up, and it falls on, well, our friend who's the producer, it falls on Australia and his neighbors, New Zealand, claim do they have a claim against Jeffzikistan as the host state, or do they have a claim against the United States as the state sponsor of the government program? And who is their claim against SpaceX against from a country standpoint, not from, you can always go after a private company.
Well, so that's a great way to begin this program, is with a law school exam question that you pose a hypo, and then the question is issue spotting. Who can sue whom for what? And the short answer to that is that anybody can make a claim. That's easy. The question is whether those kinds of claims are of the sort that the international and domestic legal systems will validate, whether you can succeed with making that kind of claim. And before I dive into that, let me give a brief overview of the evolution of international law of space. And going back to your comment about it's a little bit like the Phoenicians going out in the ocean. Because from my perspective, I see it in a slightly different way. For me, the starting point is that international law of space developed remarkably rapidly, remarkably successfully in the early years of the space age, but it's been frozen since then. Within only Sputnik went up in 1957. Within 10 years after that, the world had negotiated and brought into force the Outer Space Treaty of 1967. And that's the treaty that lays out the fundamental principles, the foundational skeleton that still guides international law of space today. And it sets out many of the principles, including those about liability and about debris and about weapons in space. That stuff is outlined in this treaty. And to have that foundation within only 10 years of the beginning of the space age is, by international law standards, breathtakingly rapid. International law ordinarily develops at a very stately pace. And the world takes decades or centuries to develop the international law of maritime law, international air law. We haven't got the infrastructure of cyberspace yet. To start that within only 10 years is breathtaking. And within only another 10 years after that, the world had negotiated 3 additional treaties, providing more of the critical infrastructure for space law. And all 4 of those documents have been joined by just about all of the leading spacefaring countries. So phase 1 of international law on space is a tale of great success and astonishingly successful promulgation of the rules. Phase 2, however, is that we haven't had anything since then. And since the 1970s, there has not been additional development of international law of space. We don't have new treaties. We haven't even gotten close to new treaties. There have been a few proposals that we could talk about that haven't really gone anyplace. And there's been some incremental accumulation of state practice and some administrative support, but the story since the 1970s is that we have not been successful at generating new law on debris, on weapons, on liability. The drafters of those early treaties did not think that they were providing all the law the world would ever need. They thought they were providing the starting point, the basic structure, and there'd be a lot more development of those principles in the intervening years, and that just has not happened. So the reason that we have so much difficulty in issue spotting, as with your original hypothetical, is that we've got some treaties that lay out the foundations, but there's been so little implementation, so little gap filling, so little details provided, that it's hard to do a definitive assessment on that. So to turn to your hypothetical, the complexity here is that the relationship between a space object and the person or country that's harmed by that space object and the person or country that's responsible for that harm can be complicated. Mm-hmm. And one crucial step on this, one way in which space law is different from all the rest of international law, is on liability and responsibility. In in most of international law, if you are harmed by a private person or corporation in some other country, ordinarily you have a claim, you have a cause of action against them. You can sue them, or you can initiate criminal proceedings. You can do something about the private person who mugged you when you were in France, or the corporation in Japan that breached a contract, or whatever private actor has harmed you. But ordinarily, you do not, under international law, have a claim against the government of the foreign country where that person was from or where the activity occurred. If you're the victim of a crime in France, you don't have a claim against the government of France.
Right.
If a company in Japan defrauds you, you have a claim against the company, but the government of Japan doesn't stand behind all the activities of their private persons. Space law is different in that respect. Under the Outer Space Treaty, every country has responsibility for the space activities of their nationals. So if Jeffzikistan allows a company to launch things into space and that satellite damages somebody else, the innocent victim has a claim against the operator, the owner, the corporation or person that launched it, but also against the country that's responsible. And that country, under the Outer Space Treaty, has a responsibility to supervise and regulate the behaviors of its nationals in space, and has a big financial incentive to do that regulation, because if one of those companies or private people harms somebody else, the country itself is responsible. So in your hypothetical, everybody is the subject of a claim. Everybody, including the governments where those people operate, is on the hook.
Even Jeffzikistan.
Even Jeffzikistan.
Yeah,
Now, the U.S. Prime Minister may not have personal liability, but the country does.
Understood. Let's take Jeffzikistan out of it, because it may be hard for people to follow along with that. But let's go with what I think is still a real life situation. When it was the USSR, everything was the Soviet Union, but their space program was launched out of what is now Kazakhstan, which is an independent state, but it's still the Russian space program. So if Russia launches stuff out of Kazakhstan, is it Kazakhstan that's liable ultimately, or is it Russia that's liable ultimately? I mean, I understand that there's a claim against both, but if we go by endorsement liability, meaning the first to endorse it is the end of the chain, who would it be? Or we can substitute, if we don't want to piss off the Russians these days, the United Arab Emirates has a space program. I'm pretty sure they don't launch out of the Emirates. I could be wrong about that, but I'm pretty sure they probably launch, somewhere else. So would it be the country where those rovers launch from, or would it be the UAE?
So this is a good example of how the underdeveloped state of international law makes it hard to give a straight answer to a question like that, because many different countries under the treaties have a relationship to that spacecraft and therefore have some responsibility for what happens when something goes wrong. Let me give you a couple of examples.
Sure.
Under Article 6 of the Outer Space Treaty, the key provision there is that states parties to the treaty bear international responsibility for national activities in space, whether such activities are carried on by government agencies or by non-governmental entities. So that means that the space activity done by a private company in UAE, in Kazakhstan, any place else, is the responsibility of the government of that territory. But it's also responsibility of the government of the nationals who are doing the action. So if there's a Russian entity, a corporation, that's doing a launch from Kazakhstan, that may count as a national activity of both Russia and Kazakhstan. Ideally, the treaty would be clearer about that. It helped you define what is a national activity and what do you do when there's more than one country involved in these national activities. The law is just not clear enough.
In essence, it's no better than if you're building a house and you hire an architect, and the architect hires a builder, an electrician, and a plumber. I mean, you sort of have a whole bunch of people, and they point the finger at each other.
But wait, it's worse than that.
Oh, no.
Because with outer space, you have not only this relationship of whose national activity it is, but in addition, there's a status called a launching state. And the launching state has special responsibility for things that go wrong with that spacecraft. And the definition of launching state is broad enough that it includes multiple countries. It includes the country from whose territory it was launched, the country from whose facility it was launched, the country that procures the launch. So there could be multiple countries that count as launching states and have, accordingly, that status. And they have that status forever. That is, even if one of the launching states owns the satellite, but then sells that satellite, it's still the launching state and has responsibility in perpetuity. And in addition to launching state, there's a special status of registration. Under the treaties, a country is supposed to register the satellites with the UN and provide some basic demographic data about the satellite. And the state of registration has special responsibilities for that as well. Ordinarily, one of the launching states would be the state of registration, but the treaties don't spell that out in great detail either.
Right. As time goes on, that'll change more and more, right?
And more countries are acquiring the ability to launch independently. And every country has the capability to procure the launching of a satellite. And therefore, every country could become a launching state and have that set of associated responsibilities as well.
You can imagine so many different. I'm not even going to go into the cynical ones where a country is just rich enough to make a satellite that has bad purposes, can't launch it themselves, but finds a rogue country that can launch it, but doesn't really care what's in the satellite, and they co-sign on communication satellite. And it is a communication satellite, but it jams all communications or something like that. So I just said I'm not going to give that hypothetical, but just did, but I'm not looking for an answer. That's too nightmarish, I think, for this show. So in our case, so it could be Jeffzikistan, but another question is this treaty that we're speaking about. There's around 195 countries in the world. I suppose that changes depending on your definition of country. Let's just use that number. Are all 195 countries signatories to this treaty?
No, and you wouldn't expect that because most of those 195 don't do anything in space, and so they've got no reason to join these discussions.
Or they have no cost in joining the treaty as well.
That's true.
If Jeffzikistan is not a signatory to this treaty, and me as the viceroy, not prime minister, the viceroy, decides to the all-powerful monarch deriving his power from the star gods themselves, decided that Jeffzikistan has absolute immunity regardless of what anyone else says. I mean, you can sue me everywhere you want, but you're not going to get any Jeffzikistani assets if we keep them in the First National Bank of Jeffzikistan.
That's true. And so first, if I may, let me begin my response as a law school professor teaching the introductory international law class and remind you of a point that I always impress upon my students. And that is, when it comes to treaties of this sort, the key phrase is not who's a signatory, but who's a party to the treaty. That these treaties, these important treaties, require two steps for a country to join: signature followed by ratification. And for a country that has merely signed, it is a signatory, it is not yet a party to the treaty. The obligations of the treaty do not apply to that state. So if you want Jeffzikistan to be a part of this treaty, you've got to not only be a signatory, you've got to be a ratifier. That makes you a party, and you're then bound by the legal obligations. The majority of countries in the world today are parties to each of these treaties, but not everybody, by no means everybody. The countries that are active in space have joined these treaties, and therefore, as a practical matter, the collection of parties to the treaty includes all or almost all the states of interest. And the pattern has been that when a new country begins to be active in space, one of the first things it does is to ratify these treaties, because that makes it a part of the club. And part of the inducement is not that you're going to be sued if you fail to comply with the treaty. It's just that others won't deal with you. Others won't help you launch. They won't let you establish ground control stations on their territory. They won't assist you in communications. They won't give you the rights that are under these treaties. So everybody has found it expedient to join the treaties when you undertake space activities.
Okay. All right. So this is a little bit of a side question. I'm not sure that you can answer this, but you did mention international business law, and so there's the business side and there's the labor side. I am struggling to figure out that when we go to space, I mean, when it's privatized, you've got captains, they're astronauts, and and the crew. But at some point, when there's commercial craft, are they pilots? Are they ship captains like the sea? Are they truckers or train, conductors like are they, would it be the Teamsters, which union would control your space going pilots, crew, and labor? I mean, when we have a ship, you've got officers, you've got the crew, you've got the longshoremen, you got the stevedores, you got the truckers that come in and pick things up. I mean, there's a whole bunch of moving parts, and it very well might be the same thing there. I mean, and listen, let's set aside that in the beginning, probably none of these things will apply. The fair or close to fair labor practices will follow. But let's just assume that we got to that place. Like, who has best claim on this? They all move cargo, right?
So, first of all, congratulations on having such a fertile imagination that you can extend into the not so very distant future many of these business and labor questions that are unresolved here on Earth. So, of course, they're going to be unresolved in space as well. That's absolute fair game. My response is that all this is to be decided. None of this has been worked out. And the one thing I feel confident about is that it will not be worked out simply by analogy. We won't say, okay, well, because there's a ship captain, then whoever pilots the future spaceship is going to be just like a ship captain. Or the rules for crew on the International Space Station must be just like the labor laws that apply on railroads. Those analogies might help suggest possibilities, but there's nothing automatic about extending from terrestrial or maritime law into outer space. Space is a different legal regime, and the countries and companies will have to make up new rules for application to that future regime. One small one that's already in play, or will soon be in play, is that one of these treaties that I mentioned, one of these first four foundational treaties, provides special status for astronauts and declares astronauts to be envoys of mankind, and says that everybody should render assistance in rescuing astronauts and returning them to their state of nationality. And that's absolutely valuable as a humanitarian measure. But who counts as an astronaut? In the current and certainly in the future era, we're going to have space tourists. And private actors will just buy seats on spacecraft that may go higher than they do now and may orbit for a longer period of time. Is a passenger an astronaut?
Right.
We don't know. When you take a commercial air flight, you're up in the air, but you're not the same status as a passenger as a pilot or as the crew. And the law makes differentiations between the status of those different categories. Something of that sort will have to happen with spaceflight as well. It hasn't happened yet, and it won't happen automatically. You won't just sort of stumble into a situation where the space tourists are or not considered to be astronauts. Somebody will have to decide, and there'll have to be new international law that regulates that sort of status.
Well, I have good news and bad news for the listener and for our guest, and the guest, I'm sure, is well aware of all of this. But basically, that concept with astronauts, sure, it's lovely, it's great that people have signed on to it, but that already sort of exists in maritime law, that when there's bodies in the sea, hostilities are supposed to end, and you're supposed to help those people in the sea. So good actors do that. Now, whether they're treated as prisoners of war thereafter or whatnot, but everyone except for the most rogue pirates do it. Even your yo-ho-ho and a bottle of rum pirates would rescue people from the sea, maybe they were hostages, but also because they knew their ship could be next. The other thing is that in at least from U.S. law, there is law on the difference between who's a member of the crew and who would be the astronaut, like the officer and part of a crew anyway, and who isn't. And so there's law on whether or not the cocktail waitress on the Carnival cruise line is a seaman or not. There's law on the people who operate the Starbucks in the international wing, if on the dock is a sea person, or the people who work at Subway on, well, it wouldn't be Subway, but on Mickey Mouse, Eats on the Disney cruise are seamen or not. So there is law on that, but it's U.S. federal law, which may or may not be mirrored and respected by other states. A lot of ships aren't even registered to the U.S., so it would only apply within docking in the U.S. territorial waters. And as you pointed out, space isn't exactly the sea. I mean, it may be the closest thing we have now, aside from the air, but aviation law largely bar from maritime law. So cheap plug to listen to the show on that. We had a lawyer who talked about the Longshoremen's Act, who actually wrote the section of the book in the Maryland Manual, and a lawyer talked about the Jones Act, which are related but not similar concepts, but also similar here as well. But way back when you talked about there was a treaty.
Just to give you one more illustration that I think your listeners might find surprising or striking, and that is to compare the law of outer space in its evolving, still primitive state with the law of air. And there's a very striking difference. With airspace, every country has sovereignty over its airspace, almost the same as the sovereignty over your land, so that airplanes from other countries have no right to overfly you without your permission. They can't enter your airspace without your permission. And that's why for commercial aircraft, there's a very dense and sophisticated network of treaties where countries X and Y exchange aerial overflight rights and landing rights. And so the United States and every country exchange, will let you fly your aircraft into our airports and we'll fly into yours. And they negotiate over how many and what routes to fly. That's because every country has sovereignty over its airspace. With outer space, it's exactly the opposite rule. With outer space, anybody can overfly anybody else in space without their permission. And in fact, it has to be that way. Orbital dynamics are such that every satellite will overfly lots of countries and cannot avoid them. The way an airplane can steer to avoid a country, satellites can't do that. And the law of outer space enables any country to have its satellites fly over anybody else without requesting permission, without giving reciprocal rights, without paying anything. Everybody can overfly in space. But crucially, the dividing line between airspace and outer space is undefined.
Right.
There's no treaty, no other international law that specifies the upper limit of the airspace regime and the lower limit of the outer space regime. So
I'm going to even top you on that. There's no scientific agreement as to what it is, and it probably varies, just like a coastline varies. I think it's called the Canaan line, K-A-N-A-A-N, and I think it's generally agreed to be around 60,000 feet high, but some places it might be 57,000, some places it might be 62,000. Maybe it varies how close the moon is or whatever.
Well, no, it's not. It's higher than that. It's usually someplace around 60 kilometers.
Kilometers. Okay, yeah. Okay.
And the idea there, it's so imprecise that you might say it's 100 kilometers, you might say it's 60 miles, and that's generally the idea that under current technology, aircraft that rely on aerodynamic lift can't really sustain flight over higher than that, and satellites generally can't come lower than that because there's too much friction with the air that disrupts the satellites. But that's just current technology. And you could imagine that those regimes as a physics matter may overlap and extend in both directions more than they do right now. But it's still striking that the two areas of law right next to each other are so very different, and there's no agreed dividing line as to which regime applies where.
Well, it is a mixed blessing that we can't agree on a border as to when the laws of the earth stop, because if we could, then all of a sudden you have maybe a bigger issue. So yeah, I'm sorry about the kilometers versus feet. Duh. But of course, we're Americans, so we can't do kilometers. We need miles. I don't even know what that translates to. It's probably 76.3 miles or something, thousand or whatever it is. Anyway, so the treaty, the original treaty that everyone basically agreed to was basically spaces to be used for peaceful purposes and shared by all. It's a little bit like Antarctica, which, by the way, cheap plug, we're doing a show in Antarctica. Cheap plug, I already said, based on what the professor said. Yeah, we had a show with a retired air traffic controller, so we talked about air traffic control. Also had a show with a retired two-star general. We talked about airport management. We have not had the aviation lawyer on yet, but yes, that's in the works. So we're going to get all of that covered as well. So little preview and more cheap plugs to go back and listen to the whole series, because it will all fit together or not fit together. It'll just be, but logically, maybe not, or thematically, maybe not logically. But where was I going with this? So I believe about 10 years later, 12 years later, there was a moon treaty. And if I'm not mistaken, neither the US nor the then Soviet Union are parties to the moon treaty, which I don't know if that's superseded by the 1967 treaty before, or if that's a new carve out, sort of saying all space. So basically the moon treaty basically said the same thing. We're going to use the moon for peaceful purposes. Everyone can share it. More, that's probably an oversimplification, but then the US and Russia didn't sign it, or then the Soviet Union. So I don't know if that means, well, we abide by 1967 and we're all going to kumbaya, or we're not signing this. So every place except the moon, we could totally claim the moon if we want to. So is there an answer? Or did I get it right first? And then is there an answer?
So I feel that I'm going to disappoint you and your listeners by constantly saying there is no clear answer on many of these points, because there's just not enough law. That we've got these tremendously important, but by no means comprehensive treaties that establish principles and some details, but not nearly enough details. This is just the beginnings of space law, and we've got these important benchmarks, but not the infrastructure that we need. So let me talk about peaceful purposes first. Peaceful purposes is absolutely a foundational part of the outer space regime. It's reflected in the Outer Space Treaty, but there are two, and it does. It has some teeth. It has some meaning that you're committed to peaceful purposes. But there are two important limitations on that. First, in the text of the treaty, this is Article 4 of the Outer Space Treaty. It says that the moon and other celestial bodies shall be used by all states exclusively for peaceful purposes. That is the moon and celestial bodies, but not the void of space itself. So this limitation, reflected in broad terms in the preamble to the treaty, but in the operational text, it's confined to the moon and other celestial bodies, and outer space itself does not have that limiting phrase.
I have a question on that point. I'm sorry to sort of interrupt, but do we even have a definition of celestial bodies? Are meteors, asteroids, are they considered celestial bodies, or just moons, planets, stars, all that stuff in the Kuiper Belt and the Oort cloud? I mean, is that covered?
So that's one of the shortcomings of these treaties is that they were negotiated in 1967. The style of treaty drafting in this area and in many other parts of international law was to be relatively brief, to confine yourself to principles. That's actually what this treaty is called. It's a treaty about principles. and to state things at a relatively high level of abstraction. In the years since then, the style of treaty drafting has changed. And now treaties are much longer, much more detailed, and typically they include lengthy definitions of terms. The Outer Space Treaty doesn't have any of that. So it does not define celestial body. I think the most commonly accepted notion of a celestial body is it's all the natural stuff in space. So it includes planets, moons, asteroids, comets, and other stuff out there, but not the empty spaces in between.
Well, what about dark matter, which is not empty, but it is matter? I mean, we're told that the void isn't exactly a void.
So take that up with the outer space experts, the physicists, and the lawyers negotiating. There's just no law on that point. There's no definition in terms. But for today's purposes, what that part of the treaty means is that there's a regime of peaceful purposes that applies to the hard places, the moons, the asteroids, and things of that sort. So that's one limitation. It applies only to the celestial bodies, not to the void of space. And the second important limitation is, what do we mean by peaceful purposes? The treaty does not define that term. Some people have argued that the way to understand peaceful purposes is that the opposite of peaceful is military. And therefore, this should be understood to prohibit military activities on the moon and celestial bodies. And that's a plausible interpretation. Mm-hmm. But the leading interpretation, the one that's been accepted by, I think, most experts, most countries, and that is reflected better, I think, in the negotiating history of the Outer Space Treaty, is that the opposite of peaceful is not military. The opposite of peaceful is aggressive. And therefore, a military activity that is intended to be undertaken in self-defense is legal because it's peaceful and could be undertaken even on the moon and other celestial bodies. That's by no means universally accepted, but I think it's the leading interpretation. So even on a celestial body, there could be measures of self-defense that would qualify as peaceful, even on the celestial bodies.
Well, it would have to be because there's already tons of military satellites up there from a host of countries. So,
well, there you go, and that's absolutely the case. That from the very beginnings, the predominant, the leading uses of space were military, and they were said to be self-defense. Today, we've seen this enormous growth in the commercial side, but it's still the case that a lot of many of the most common and most expensive and most valuable functions in space are military related and said to be justified as self-defense, not as aggression.
So my beloved Space Force, as long as they're not attacking anyone, they're probably okay. Of course, they don't have any
an attack in self-defense would be a peaceful purpose.
Well, that's a pretty big loophole, but that's what us lawyers like, right? Okay, so that moon treaty that we're not a part of, I mean, what's your take on? Is it meaningless? Is it just one of those things? Does it not matter so much because the USSR doesn't exist any longer?
So the general proposition under international law is that a treaty cannot confer rights or obligations on non-parties. So the treaty has meaning only for the countries that have joined it. And the Moon Treaty, unlike the other four that I mentioned earlier, the Moon Treaty has not attracted very many parties. I think it's only got 18 countries, and none of them is a major space player. Some of them are active in space, but they are not the major players. And you're just right, the United States and the Soviet Union or Russia or China, most of the European countries, Japan, South Korea, the countries that are active in space have not joined the Moon Treaty and therefore have no obligations under it. And part of the reason they've stayed away from the Moon Treaty, not the only reason, but a big part of the reason, is that the Moon Treaty establishes a set of rules for resource exploitation on the moon and celestial bodies. and sets up a regime for sharing the access to the resources, a regime that the high-tech countries that would be in a position to exploit those resources soonest, many of them are not so interested in sharing the benefits. They're interested in grabbing those benefits and saying, this is mine, and not in sharing. The Moon Treaty, in this respect, is intellectually the successor to, maybe you've addressed this aspect of the Law of the Sea Convention, which establishes that certain resources of the deep ocean, these mining of the ocean floor out beyond the areas where coastal states can claim special rights, those far offshore resources are declared to be the common heritage of mankind, and nobody is allowed to mine those resources without getting a license from the organization that was established under the Law of the Sea Treaty. And the Moon Treaty would be a step in that direction. It would also declare that the resources, the minerals and other resources of the moon are the common heritage of mankind, and would look towards setting up some sort of international structure where any country or company that wanted to do the mining would apply for a license, pay a fee, and get the authorization to conduct that mining. That declaration that the resources of the moon would be the common heritage of mankind is what's kept most of the high-tech countries away from the Moon Treaty, and accordingly, they have no obligations under it.
It's funny you mentioned the Law of the Sea. So again, a cheap plug to listen to that show, but Professor Doremus definitely did not want to play my Jeffzikistan, which then was not an organized state, but it was more like a Blofeld villain from Bond. She didn't want to, play those hypotheticals, and I'm not going to put them on you because that's not the topic of this show. Though it's similar, Moonraker. I mean that sort of thing. But I want to stick to what's in the real world because it's interesting enough, and that is the last administration, which created the Space Force, which I love, by the way. I mean, it's one of the few things I truly love that the last administration did. They also issued an executive order, which I'm not even sure of the constitutionality, the enforcement or whatever, but the executive order basically said, hey, if you're a U.S. company, you can go to these celestial bodies, including the moon, including other planets, including asteroids, and you can harvest whatever you want. It's not shared for everyone. You just can't claim it for yourself. So it was sort of a combination of America first, but not you. But you can't name it Planet Elon or Moon Elon or you Bezos. It's still America's. But if you get there, you can harvest it all you want. I'm trying to think of like the first gold company that got out west. I don't know it. So, but we'll just call it the evil Jeffzikistan gold country. Same thing here. The evil Jeffzikistan asteroid harvesting company or moon harvesting company. I mean, under that executive order, I could go take it all, not share it with the world. But in essence, I'm also Marvin Martian. I'm claiming it, but a Marvin Earth. I'm claiming it on behalf of, well, not Marvin Earth. I'm Marvin United States. I'm Captain America. I'm claiming it on behalf of the United States. Does that executive order hold any water? Does it have any standing? I mean, did it scare everyone? Did everyone just laugh it off? I mean, what's your reaction to that? Because obviously when you heard that, you had to have some reaction to it.
Well, you put your finger on one of the biggest, hottest, toughest controversies in space law and practice today. And that's the legal regime for mining or harvesting other resources on the moon and celestial bodies. And that's absolutely the current controversy. And there's tension between legal authorities here. The starting point is again the Outer Space Treaty, and it's Article 2 of the Outer Space Treaty that specifies outer space, including the moon and other celestial bodies, is not subject to national appropriation by claim of sovereignty, by means of use or occupation, or in any other means. Which means that no country can claim the moon or parts of the moon or an asteroid or part of an asteroid. You can't claim this is mine. That is, it's directly rejecting the way the European colonial powers claimed parts of the New World as theirs. Under the prevailing norms of that era, that was something countries could do, and countries had to respect each other's claims unless you could wrestle the claim away from them. With outer space, the treaty prohibits that. You cannot claim the moon is mine. However, some enterprising interpreters in the United States and elsewhere have said, okay, so I'm not going to claim the moon is mine, but what I am going to claim is that I can extract the resources from the moon and claim those resources as mine. I'm going to find water or platinum or something else on the moon or the celestial bodies that I want to claim. And I'm not saying this land is mine. I'm saying the resources, once I extract them, are mine, and I can use them, I can sell them, I can bring them back to Earth, I can use them to advance my own other explorations in outer space. And the United States has been one of the leaders in offering that interpretation. And today, it's not just the executive order. Today, there's a statute passed by Congress and signed by the president that claims that Americans can make a valid claim to resources extracted from the moon and other celestial bodies. And a couple of other countries have done the same thing. Luxembourg, for example, although a very small country, has become the headquarters for a number of space operations. And part of the reason that companies want to locate in Luxembourg is that Luxembourg has a statute that enables its companies to claim the resources, not claiming the moon, but claiming the resources as their own. And United Arab Emirates and maybe a couple of others have moved in the direction of authorizing private companies to own the resources they extract. And some think that that's a valid interpretation of Article 2 of the Outer Space Treaty. Others say that it's not valid, that the distinction between claiming the resource versus claiming the territory is a bogus distinction.
Well, a couple points to that. First of all, I'm angry at those countries for stealing Jeffzikistan's entire business model. So I'm upset about that. The other thing is I was wondering about the executive order because, listen, the Article 2 executive is commander-in-chief over the military, but this isn't military. And the 1967 treaty says non-aggressive we talked about not all military is aggressive, but, I guess if you directed the Space Force to start harvesting materials, you could circumvent Congress, I suppose, if they funded it. But the other part is if an executive order, it can't take a country out of a treaty. I mean, treaties have to be ratified by the Senate. So, but this statute you're talking about, that was by Congress and the president. So that statute probably is of more concern than the executive order if you're another country. And maybe if you're in this country and worried about, forming the new, not the British East India Company, but the American East India Company, but extrapolate directions and space, to make it the American Lagrange three-dimensional harvesting company or whatever. So I can't imagine that a lot of countries were very pleased about that statute as well.
Well, so what you have to, the mind game you have to play there is, which way does any particular country have an interest? Are they more likely to be one of those who says, well, we could have the technology to go up into space and grab those resources too. And we could be among the first come and therefore first served. Or are you a country that says what we want is sharing and have some equitable means of access to these resources? The United States has undertaken an effort to get countries to agree to this concept of the U.S. facilitating private companies exploiting resources of the moon and celestial bodies. And the mechanism has been what's called the Artemis Accords. Mm-hmm. The Artemis Accords is not a treaty, it's not legally binding, but it's a cooperative arrangement among the United States and like-minded countries that will include their participation, shared participation in a wide variety of space activities, including authorizing their companies to do this kind of resource exploitation. And now there's something like 20. I think today they just recently announced 20 countries. The 20th country have joined the Artemis Accords. And many of them are the high-tech countries that would imagine that they too would be in a position to do this grabbing of the resources and might find it economically advantageous to grab rather than have to share.
Right. Well, it's funny that you said the United States is leading it, because I'd have to go back and listen to the Law of the Sea show, but I remember that Professor Doremus was talking about an international convention, which, the United States was often citing, but itself was not a party to, didn't agree to, though it still seems to abide by it. But I mean, sort of like the International Criminal Court. The United States tries to abide by it, but we're not subject to its jurisdiction. So, I don't know how many times you can sort of get away with that, but I guess you can if you're the top dog. As long as you're the top dog, I guess you can. Anyway, I don't want to get bogged down on that, because you've been very gracious with my hypotheticals and my games in Jeffzikistan, and this is a very serious topic. I didn't want to forget the Woomera manual that we're going to end with that, because I think that's sort of an outgrowth of the Artemis Accord. I'm just wondering, before we get to that, how does this new private sector interplay? I mean, in some ways, there's more space activity from private companies than there are from governments. So does that throw a wrench into everything? I mean, they haven't bound themselves by treaties. And listen, I'm not saying this is the same. I don't even know the name of Bezos' space company, but I hear plenty of people saying Amazon doesn't pay taxes in the U.S., which I assume means it's organized under the laws of another country, but probably has 80% of its facilities here in the U.S. Is it the same thing? Their space company is there, and they're not considered the U.S. actor thereby. So I think you know where I'm going with this, and I'm sure that because this is your profession, Professor, you can enunciate it far better than I can. So what's the monkey wrench, or is there a monkey wrench?
So you're absolutely right. This is the I was going to say new, but it's now at least 10 years old. This is the new phenomenon in outer space, is the enormous growth in private sector activities in space. And it is a big change, and a very important change. And you're just right that there's now a number of companies, SpaceX and Planet and many others, that have announced plans and have begun the process of putting up large numbers of satellites. And just to give you a sort of an order of magnitude sense of this, if you're counting how many active satellites there are in space, it's not so easy to do. And the box score would be different depending on different authorities. But if you were looking at, say, the year 2000, you might say there's someplace on the order of 1,000, maybe 2,000 active satellites in space. SpaceX is going to put up 40,000.
Wow.
And other companies are going to put up similarly sized constellations. And other countries are hosting private actors that will be doing that as well. So the population of space objects is about to mushroom orders of magnitude beyond what we've had up until now. Now, many of these are very small satellites, in contrast to the government satellites that tend to be very large and very expensive. So the total mass in space isn't quite going up by that huge volume. But this is a huge change in the orbital population, and a huge change in the cast of characters that are relevant in space. And one of the legal implications is that you're just right. Treaties are joined by countries. Treaties impose obligations upon states. Jeff Bezos does not sign these treaties. But this treaty, the Outer Space Treaty, and the others, impose on countries obligations to regulate their nationals' activities in space. So SpaceX is indirectly regulated by the treaty, not as a party to the treaty, but because it's a national of a country that is a party to the treaty. During the negotiations of the Outer Space Treaty in the 1960s, the Soviet Union took the position that only countries should be active in space. Only states should be allowed to put up satellites. And the United States objected to that and said that companies, corporations could be players that would contribute to space activities, and corporations should be allowed to be active in space as well. The compromise under the 1967 treaty is that corporations can do things in space, but the country is accountable. The country has a responsibility to regulate and supervise and is accountable if something goes wrong with a satellite put up by the company. So you're just right. The law directly applies only to states, but indirectly it applies to the non-state actors as well.
So the country is the co-signer in essence for the private company. So, be careful about too big to fail, but the country still polices as long as the government's bigger than the business. So what about that Amazon situation? Because listen, I don't know. I haven't looked into this. I don't do tax law, but I assume Amazon is organized under the laws of some other country. I mean, what if it's poor Grand Cayman or Cayman Islands? Are they the ones that are responsible, or is the U.S. responsible?
Well, that's what we talked about earlier, that a particular space object may have a connection to multiple countries, and multiple countries may therefore have responsibility or liability or accountability if something goes wrong. And
so it could be minimum contacts. It could be Amazon does business in 130 countries around the world. They all could theoretically be co-signers.
I want to caution you not to automatically use terrestrial legal vocabulary and contexts to apply to outer space.
Fair enough.
That's just not the legal regime. We don't have co-signers. We have launching states. We don't have, we have different legal relationships that apply under outer space law, not completely well worked out, not thorough, not as dense as it needs to be, but there's a different legal regime that applies different rules from those on land, sea, or air.
Interesting. Well, it seems that one of the things they should define is what's a launching state, to clarify that it's actually the geography. It's actually based on upon which the launching pad sits.
Now these days, sometimes you launch from the ocean, and they can recover on a floating pad. So again, you got to break out of the familiar legal categories to confront a different physical reality.
Well, that's a problem for other people, but what I hear is Jeffzikistan is back in business. All right, let's get off of that. Let's get to the Woomera system and the Woomera manual, because listen, you're quoted in Jeremy Conrad's article. There's not a lot there. There's a nice picture of you. You look happy. You're living up to your happy picture, which is great. But basically, you said that you're cautiously optimistic that everyone will behave properly because businesses do better when things are predictable, and they won't behave because of philanthropic or, they'll do it for enlightened self-interest. It's better if everyone behaves. The cynic in me says, yeah, until they can get their hands on a $45 trillion asteroid. But let's set that on the side. First of all, am I correctly paraphrasing you?
Yes, it does seem to me that international law, like domestic law in the United States and other countries, works best when the rules reinforce self-interest. Here you got to rely on enlightened long-term self-interest and try to structure things so that cooperation serves the interests of everybody. And the Woomera manual is a good place to start with that. This and let me, if I could, give you a little dose on Woomera, because this is, I think, one of the most exciting things that's going on in outer space law today.
Absolutely.
And because I've just now returned from 10 days in the Netherlands where we were working on the Woomera manual and had a very successful conference there. So let me describe what this project is. This is an effort led by a number of universities in Australia, the US, England, and elsewhere, to try to draft a manual that would lay out the current international law relevant to military activities in outer space. And it's sort of remarkable that there has never been a codification, a treatise that analyzes the specialized area of law that's applicable to military activities in outer space. And it's remarkably complicated because in general, what we've got in international law is that there's some generally applicable international law, the UN Charter, the Vienna Convention on the Law of Treaties, the treaties on diplomatic relations and so forth. Those are general international law. But there are also some areas that are specialized international law, where a particular corner of practice has specialized rules that apply to that subject and to the practitioners in that field. And in general, in treaty hierarchy, the specialized areas prevail over the general areas. Outer space is a specialized area. And we've already described in this conversation a couple of ways in which the international law of space is different from the international law that applies elsewhere. In Latin, we call that a lex specialis. Outer space is a lex specialis. The law of armed conflict is another lex specialis. There are particular rules about warfare that are different from the rules about peacetime. And you got to know which situation you're in, and you got to understand the specialized rules for military activities. When there are military activities in outer space, you've got two different lex specialises overlapping, and nobody has yet written a manual that would clarify how that overlap should be handled. What rules prevail as between the two specialized areas of outer space law and the law of armed conflict. So what this group of private practitioners did was to draft a manual. We sent it to the governments of many countries, and to our surprise, 25 of them showed up for this conference and gave us comments on this draft manual. And so we're now in the process of integrating those comments from all the participating countries and trying to refine and improve, edit this manual with the hope that it'll be distributed, published later this year, and then will be available to countries. At this meeting in the Netherlands, we had ministries of foreign affairs, ministries of defense from countries that are very active in space and countries that are not so active in space. And all of them gave us this kind of feedback that we're now in the process of editing this draft manual. I should also mention it's called the Woomera Manual, after a town in Australia that has been the center or the originating place of the Australian space activities. And because it was a couple of Australian universities that provided the lead for this enterprise, they gave it that specialized name.
Well, our producer today is from Australia, so I'm sure that he's beaming with pride. I was going to ask you if it was Australian, but I figured that was too trivial a question. Even concerning my other questions, which were maybe not trivial, but not realistic for me, but maybe someone. I mean, Putin, maybe, I don't know. Anyway, he just messaged he was actually beaming with pride. Anyway, so this is cause for optimism. And listen, congratulations on being part of this effort and to get the 25 countries to show interest. Because once you get 25 countries, I imagine, if you're doing it again next year or whenever, that number will probably triple, I would think.
And it's also noteworthy that they don't always agree with each other.
Sure, of course not.
This is an area where the international law, as I said, is obscure and evolving. And our effort in this manual is not to state what the law should be. It is instead more modestly to state what the law currently is. Mm-hmm. And because there are not enough treaties, there's not enough density of the existing international law, you look at what countries say and do and try to interpret their behavior as constituting evolving customary international law or interpretations of the treaty. And that's a very delicate interpretive process.
I imagine some of the things that you couldn't interpret today because there is no agreement. I'm sure some of those things, still building a foundation. But this is not the Council of Nicaea. It's whatever the first one was, which I think was in Constantinople, or I don't know. I don't know the order of those things. I just know that Nicaea was the last one. Anyway. So still, congratulations. Great. Hopefully, maybe even I gave some food for thought. I tend to doubt it, but whatever was, there's plenty there. What is peaceful? What is a celestial object? And maybe we can agree on the borderline of where the atmosphere ends, and if that should matter or not. This is really fascinating, and I can't thank you enough for your time and your expertise playing along with this. Again, this is a podcast, so I want it to be informative, educational, but also entertaining. I try to strike the balance. Sometimes I fail, but if somebody's willing to play along with Jeffzikistan and my Bond villain things, it makes it a little bit easier than someone who goes, no, nobody would do that. So yes, you have to imagine somebody will always do that if they can. So I can't thank you enough. Is there anything that you plug other than enrolling in your class and applying to Georgetown? I mean, do you have books? Do you have your own show? Do you host a website where you write articles? Is there, anything in Professor Koplow's world that the listeners can support or look to just if they want to read more of your work or learn more about you?
Well, so most of my writing is law review articles, and the audience for a law review article is very limited. I heard long ago, I'm not sure how true this statistic is, but it's at least illustrative, that the average readership of the average law review article is 8 readers, and that includes the author's parents. So I don't have any illusions that anything that I write is going to be widely disseminated. But if anybody's interested, you can just go to the Georgetown Law Center website, and there's a button there for faculty members, and each faculty member has a web page, and you can get a click through to my bio that gives you links to the space-related and other articles that I've written. If anybody's interested, there's that. One other thing I could put a plug in on is that I've been involved in a project with the National Academy of Sciences that established a committee to study what they call the public-private partnerships in space. We've talked about today about how the surge in private sector activity is creating what some people refer to as new space. Old space being dominated by governments, new space being a combination, a hybrid architecture of government and private sector. And the National Academy has just issued this new report on leveraging public-private partnerships for national security and other purposes. And if anybody's interested there, you can go to the website of the National Academy, and they're doing a workshop on this on Monday and Tuesday that people could register for and attend on that subject.
Wow. Well, that's terrific. Actually, I am interested in that. So that's terrific. So again, I can't thank you enough. Listen, you're welcome back anytime if you have more to report and you're willing to come into the view again. Please don't be a stranger. Really appreciate it. Good luck with everything. I feel secure knowing that there's folks such as yourself trying to avoid there being another Hudson Bay company, and hopefully it'll all work out. So, folks, please take a look at the Georgetown Law website, read the stuff, check out that seminar, and while you're at it, rate and review the podcast too. Give us 5 stars and a review. If you subscribe to Garden of Doom, you get Garden Views automatically. Unfortunately, if you don't subscribe to Garden of Doom, you can't find Garden Views because I'm cheap and we share the same feed. But other than that, thanks so much. We're going to continue to follow this theme. And Professor, thank you again. Have a great night.
Thanks. It's a great pleasure being with you.
Pleasure was mine. All right, Jimmy, I think we're done.